Hello, welcome to your week 11 module. This week we'll be discussing chapter 10, policing and the law. I thought that this video was fitting, so be sure that you click on it to hear the theme song to Law and Order. So this chapter will give us an insight into the constitutional amendments, some of them, and how they affect the field of policing. We'll first start with the Fourth Amendment. The Fourth Amendment of the Constitution occurs, or a violation of that amendment occurs, when a government actor infringes on a person's reasonable expectation of privacy during a search or seizure. And you may say, well, why would I be in a position to be searched or seized? It could be something as simple as a traffic stop. It could be something as simple as them coming to your door and wanting to come in because they think that a suspect is there, that you may have something inside that will incriminate you. Before an officer can stop you to search or seize you, they have to have probable cause. Probable cause, your text defines it as 50% of certainty. That's also a term that they use in policing called reasonable suspicion. So that means that they just have to have a hunch that you've done something, and then they can come and further investigate, which may lead to probable cause if there's something there that shouldn't be. Probable cause is something that came up in our first stop and frisk case that the United States Supreme Court decided on, Terry v. Ohio. This case permits police to briefly detain someone to determine whether criminal activity has been committed or they're about to commit criminal activity. So this pertains to the Fourth Amendment because when they stopped you or stop you because they suspect that criminal activity is going to occur or has occurred, are they seizing you? Do they have a right to search you? Stop and frisk says that they have a right to pat you down and to ask you general questions to see if there may be something that they need to further investigate. So the Fourth Amendment, as I said earlier, is defined as the amendment that governs search and seizure. Excuse me, I got kind of tie-tongue there. A search is defined as an activity performed in order to find evidence to be used in a criminal prosecution. So when they're searching you, they are searching for evidence that can be used to prosecute you. The seizure is the confiscation of one's person or an arrest or property by a government agency. So you may say, when I'm stopped alongside the road for a traffic violation, am I seized at that point? A lot of officers would say that they are detaining you. They'll let you know. If you're under arrest, then you are being seized. The detention, they have up to 2 hours that they can detain you just to investigate, and that sometimes, if they find probable cause, can lead to the search of your vehicle and your persons. So let's define probable cause. A set of facts and circumstances that would induce a reasonable, intelligent, and prudent person to believe that another particular person has committed a specific crime. So pay very close attention to those words: reasonable, intelligent, and prudent. What exactly does that mean? I can be reasonable to you, and someone else may think that I'm unreasonable. How do we define those terms? And those are gray areas because it would take the judge or the jury to decide if that person was reasonable. And that answer may vary from one person to the next. Probable cause is the only justification, as I said earlier, for search and seizure mentioned in the Fourth Amendment. So remember that. I think I asked earlier how many constitutions you have. We actually have two: the United States Constitution, which is the law of the land, and each state will have its own constitution. Each state will have its own constitution. So let's talk a minute about searches. When can an officer search you? Of course, he can ask for permission. Can I search your vehicle? And you can give him consent to search. And then he can have probable cause to search. Say he has a smell of marijuana coming out of your vehicle. That may lead him to want to search to investigate further to see if you actually have marijuana in your vehicle. There's also something called exigent circumstances. and that's where an officer does not have to have a warrant, such as a hot pursuit, or he thinks that someone may be escaping, or you're going to destroy evidence, and they can come in and search without a warrant. There's also the plain view doctrine. This is the rule that the police may seize evidence without a warrant if they have lawful access to the object and its immediate apparent that the object is subject to seizure. So plain view is something that's in their plain view. Just hold your arms out for a minute for me, stretching from side to side, front and back. That's called a wingspan. So whatever officer within that reach, whatever he can see, then he has a right to search. This happens sometimes at checkpoints. If something is suspicious or they have reasonable suspicion or probable cause, then they will investigate further, which may unfortunately lead to your arrest. So lastly, this chapter will discuss confessions and interrogations. It brings up the landmark case Miranda v. Arizona, which was decided by the Supreme Court in 1966. Miranda is a very talked about subject, and most people assume that when they're stopped by the police or they're arrested by the police that they have to be Mirandized. That is not true. The Miranda rights or Miranda warning only pertains to interrogation or questioning of a suspect. And this doesn't include general roadside questions like where were you going? Do you know you were speeding? This means that they are questioning you to further their investigation, to get a confession out of you, or to find out more information. So, of course, before they start questioning you, they will Mirandize you. This you're protected by the 14th Amendment as well as some the constitutional amendments, and this guarantees that they don't infringe upon your due process rights. So Miranda will be read, which is you have a right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford one, one will be appointed to you. They'll ask you if you understand those rights, and you'll say yes or no, and if you want to talk from there. So this chapter will give you an overview of Miranda. It'll talk about the Fifth Amendment of the Constitution, which is an amendment that establishes the due process rights, just like the 14th, which is the Bill of Rights. And it's included in you not being able to self-incriminate yourself. So jump right in. Make sure that you read the entire chapter. We have a lot of court cases in this chapter, which can be helpful. Terry v. Ohio, I mentioned that earlier. We have Florida v. Bostic. A lot of landmark cases. Schimel. I think I mistakenly cut myself off on that last slide, so forgive me, please. But again, this chapter will just give you an overview of all those important cases of the law as it pertains to policing. And lastly, I have listed here some of all of your constitutional amendments. So be sure that you take a good look at these, because this pertains to not only the field of criminal justice but to your everyday life. You should know the amendments of the Constitution. So you guys have a great week. Feel free to reach out to me if you need me. Bye-bye.